Welcome to Professor Meiselas' classroom. We're going to talk 14th Amendment, Section 3, disqualification. We're going to give you the most thorough analysis you've ever heard about disqualification. I'm going to explain to you, while I believe personally that Donald Trump should be disqualified under the 14th Amendment, Section 3, my personal opinion diverges from what the Supreme Court ruling was back on March 4th of 2024. It was a 9-0 decision, although there were some other kind of concurring opinions that differed from the majority opinion. But let me be very clear what the majority opinion held in the Anderson case that was decided by the Supreme Court on this issue, and it was decided on March 4th, 2024. It held that in order for there to be a disqualification of someone running for a federal office like the presidency, Congress has to pass a law that would require the disqualification. It takes an act of Congress under the 14th Amendment, Section 5. Now, again, I personally disagree with that interpretation. When you look at some of the concurring opinions which diverge from the majority opinion, even though they all agree that the Colorado ruling, which held that Donald Trump was disqualified, was invalid and they overturned that, the concurring opinions said the majority opinion went too far in basically saying that Congress needed to pass legislation, but that simply is the law. Now, I'm not just going to do this by conjecture. We're going to go through the opinion together so we can resolve this issue once and for all. And again, let me make it very clear. My own personal view is Trump should be disqualified. My own personal view is that the Supreme Court got this wrong. But the Supreme Court, they decide, they interpret the United States Constitution. Their ruling is final here, and there's simply nothing else to do once the Supreme Court ruled. I would like there to be something else, but the Supreme Court said it requires legislation from Congress in order to disqualify Donald Trump. Now, the current composition of Congress is such that the Republicans control the House of Representatives, and they will be controlling the Senate as well. So how are you going to convince a Republican-led Senate and a Republican-led House to pass legislation to disqualify Donald Trump? It simply, in my opinion, is not realistic. And I simply want to give you what my opinions are that are realistic. But let's not talk about opinions. Let's go through the order of the Supreme Court. Let's go through the text of the 14th Amendment first, okay? So 14th Amendment, Section 3, let's just read it out together, okay? It says, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Now, again, for me, this language is clear, and my opinion, though, is rejected by the Supreme Court. Now, as I read this, what it clearly says, at least to me, is that if you engage in an insurrection, the way Donald Trump did, he's someone who holds an office. It says any office at all. By engaging in an insurrection, my view is that this is self-executing, meaning you're an insurrectionist, and what it actually requires is a vote by Congress to say you are not an insurrectionist, to remove the disability. The disability being that you are an insurrectionist. That's what people mean when they say, is it self-executing or does it require some sort of legislation, which would mean it's not self-executing? I believe it's self-executing. The Supreme Court ultimately disagreed with me, and I'll go and show you the Supreme Court ruling where they did disagree with me. But as I read it, remove such disability means the disability exists once you engage in an insurrection. Finally, the 14th Amendment, Section 5 says, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Now, I don't think that meant that in order for there to be a disqualification of Donald Trump or someone in federal office who engaged in insurrection, Congress needs to pass legislation. To me, this just means legislation can be passed to effectuate what's already being said in Section 3, which Section 5 should not contradict what's in Section 3. But again, the Supreme Court disagreed with me and said what Section 5 means, the only way you can disqualify Trump, again, according to the Supreme Court, is that Congress must pass legislation. And now ask yourself, how's Congress controlled by MAGA Mike Johnson in the House and controlled by MAGA Republicans in the Senate? How are they going to pass that legislation now? But again, don't just trust my opinion. Let's just go through the opinion. Now, this isn't the first time I've covered this. There are numerous videos where we've covered this on the MeidasTouch network before. A year ago, we had experts like Harry Litman. Harry Litman clerked for 2 Supreme Court justices. He was a top federal prosecutor in Pennsylvania. You don't get more experience than someone like Harry Litman, or equally experienced. We had Judge Ludwig. Judge Ludwig wrote the amicus brief, which aligns pretty closely with my view. And that view is this is self-executing. Trump's an insurrectionist. Trump should be inherently disqualified, and that states can have the right to remove Donald Trump's name from the ballot or just generally have him be disqualified from being in office at a federal level because he engaged in insurrection. Judge Ludwig thought it was simple also, but again, the Supreme Court disagreed with renowned retired federal Judge Ludwig and with me, but we've had Ludwig on multiple times to discuss this. So just how this case ultimately get to the Supreme Court, called Donald Trump v. Anderson, which we refer to as the Anderson case. Well, a group of petitioners, a group of people filed a lawsuit, and they filed these in various states. But the one in Colorado eventually got to the Colorado Supreme Court after an unfavorable ruling at the trial court level. And the Colorado Supreme Court, their top state Supreme Court, said that Donald Trump is disqualified, basically using my analysis. They said that he's an insurrectionist. It's basically self-executing. Therefore, Trump should not be on the ballot in Colorado. It's a very simple analysis. They had an evidentiary record, but they stayed their ruling, meaning they paused and stopped their ruling, so Donald Trump can go to the United States Supreme Court. Why the United States Supreme Court? Because that's the supreme law of the land. Under the supremacy clause of the Constitution, the Supreme Court resolves these issues, and the Supreme Court has the ability where a state court chimes in on something related to federal law to say the federal law and the federal constitutional interpretation by the Supreme Court is supreme. And you may say, why does the Supreme Court have this authority? They do. The overwhelming precedent is the Supreme Court interprets the Constitution. They make a ruling about the Constitution, and that is final. If we disagree with it, we could try to challenge Supreme Court precedent the same way over time Roe v. Wade was overturned over whatever it was, 30, 40, 50 years. Roe v. Wade was overturned in Dobbs. You'd have to convince this same Supreme Court that just unanimously ruled against my opinion to suddenly flip what they just did in March of 2024. And that never happens. Precedent doesn't get changed within the same year. If precedent gets changed, it's not supposed to be changed at all, but it takes decades of time and a new composition of the Supreme Court to do that. So the Colorado case goes to the United States Supreme Court, and the United States Supreme Court says, hold up, Colorado, hold up. People who view it how Ben viewed it, you're wrong. It requires legislation from Congress if you want to disqualify Donald Trump. Let's just look at the opinion together. And again, this is going to be detailed and thorough. There's not going to be any gaps in this analysis, so you can see for yourself. Let's just look at the first page of this opinion by the Supreme Court. You see March 4th, 2024, Trump versus Anderson. You see right here it says per curiam decision. That means this is a decision of all 9 members of the court. It's unanimous. It's 9-0. We'll see there are some disagreements in how some of the justices got there, but a majority ruled the way I'm about to share with you. And we'll go through some of the nuances of how Justice Amy Coney Barrett thought about things, and she's appointed by Trump, and separately how Judge Ketanji Brown Jackson, Judge Kagan, and Judge Sotomayor, who were appointed by Democratic presidents, they reached the same conclusion, but differently. And you'll see that those justices ultimately were saying, man, the Supreme Court majority went too far here. We think that the states don't have a right to disqualify Trump, but the majority went too far by saying that legislation by Congress is required to disqualify Trump. The Supreme Court shouldn't have gone that far, and the majority is what these 3 justices who were appointed by Obama and Biden said. We'll read it together. So this is from the majority opinion. Take a look at what I've highlighted here for you. It says, former President Trump challenges the decision on several grounds to disqualify him from Colorado. This is what the Supreme Court rules. Because the Constitution makes Congress, rather than the states, responsible for enforcing Section 3 against federal office holders and candidates, we reverse, meaning they're overturning the Colorado Supreme Court's decision, which disqualified Trump, and saying Trump's not disqualified in Colorado. And then it goes on to say the following, that the Colorado court, Supreme Court, found that Congress I'm highlighting it here on page 3, that Congress need not pass implementing legislation for disqualification under Section 3 to attach. That's what the Colorado Supreme Court held. And now the United States Supreme Court, which is above the Colorado Supreme Court on issues of federal law and constitutional interpretation, says Colorado got it wrong. Where do they say that? Let's look at page 5 together. And again, this is the law of the land. This is the status of the law right now. The Constitution empowers Congress to prescribe how those determinations should be made. The relevant provision is Section 5 of the 14th Amendment, which enables Congress, subject, of course, to judicial review, to pass appropriate legislation to enforce the 14th Amendment. Or as Senator Howard put it at the time the amendment was framed, when the 14th Amendment Section 5 was created, Section 5, quote, casts upon Congress the responsibility of seeing to it for the future that all the sections of the amendment are carried out in good faith. Then it goes on to say on page 6, this case raises the question whether the states, in addition to Congress, may also enforce Section 3 of the 14th Amendment. Remember, I read you what Section 3 said? We conclude that states may disqualify persons holding or attempting to hold state office, not federal office, state office, governors, state representatives, not federal. Then it goes on to say, but states have no power under the Constitution to enforce Section 3 with respect to federal offices especially the presidency. Especially the presidency, states can't get involved. It goes on to say on page 7, the respondents nonetheless maintain that states may enforce Section 3 against candidates for federal office. But the text of the 14th Amendment on its face does not affirmatively delegate such a power to the states. The terms of the amendment speak only to enforcement by Congress, which enjoys power to enforce the amendment through legislation pursuant to Section 5. That's a key point. It's saying that the power to disqualify is in the hands of Congress, which enjoys the power to enforce Section 3 pursuant to Section 5, meaning the passage of legislation. It goes on to talk about on page 12, it says, the patchwork that would likely result from state enforcement would sever the direct link that the framers found so critical between the national government and the people of the United States. But in a presidential election, the impact of the votes cast in each state is affected by the votes cast, or in this case, the votes not allowed to be cast for the various candidates in other states. An evolving electoral map could dramatically change the behavior of voters, parties, and states across the country in different ways and at different times. The disruption would be all the more acute and could nullify the votes of millions and change the election result if Section 3 enforcement were attempted after the nation has voted. Nothing in the Constitution requires that we endure such chaos arriving at any time or different times up to and perhaps beyond the inauguration. Now, I think that is a critical line as well, because I've heard some people say, look, all the Supreme Court ruled is regarding whether or not a state can disqualify Donald Trump from being on a ballot. And the Supreme Court found that Donald Trump could not be disqualified from a ballot, that Trump's name had to go on the ballot. But that's it. It doesn't talk about inauguration or what happens after Trump is on the ballot. It does talk about that. I just read you the line where it talks about it. And it's saying nothing in the Constitution requires that we endure such chaos. And again, I don't think it's chaos. Personally, my own Ben opinion is that if you're an insurrectionist, you should be disqualified, and that the 14th Amendment, Section 3 is self-executing. I'm simply reading for you what the Supreme Court is saying in their opinion, which is saying they want to avoid disqualification at any time unless Congress passes legislation. And they specifically say at any time or different times up to and perhaps even beyond the inauguration. Then it concludes on page 12. For the reasons given, responsibility for enforcing Section 3 against federal office holders and candidates rests with Congress and not the states. Then it goes on to say all 9 members of the court, this is page 13, all 9 members of the court agree with that result. Now they talk about why there's some of their colleagues write separately. Our colleagues write separately further agree with many of the reasons in this opinion. And it goes on to say, so far as we can tell, they object only to our taking into account the distinctive way Section 3 works and the fact that Section 5 vests in Congress the power to enforce it. These are not the only reason the states lack power to enforce this particular constitutional provision with respect to federal offices, but they are important ones, and it is the combination of all of these reasons set forth in this opinion, not as some of our colleagues would have it, just one particular rationale that resolved this case. In our view, each of these reasons is necessary to provide a complete explanation for the judgment the court unanimously reaches, all of them. The judgment of the Colorado Supreme Court is reversed. The mandate shall issue forthwith. So you see here, the majority, which that means that's what the law is when you get a majority, they're saying, look, we all agree Donald Trump should not be disqualified. And again, I view Trump should be disqualified, but all of the Supreme Court justices say Donald Trump should not be disqualified. It's hard to get the Supreme Court justices to agree 9-0 that the sky is blue. So the fact that they are unanimous in this, is a pretty drastic thing. But you have some of the Supreme Court justices who are not in the majority saying, whoa. You've gone way too far, majority, by saying that the only way you can disqualify Trump is through congressional legislation. Why are you even answering that question? You shouldn't ever go there. And the majority saying, we have to go there. We want to resolve this for good. We want to make it clear it's got to be legislation from Congress. And again, I disagree with that. I think it's self-executing. The majority says it is not self-executing. It requires literally a law would have to be passed from Congress, from both chambers, which will be controlled by Republicans, saying that Donald Trump is disqualified. And again, when I go and read 14th Amendment Section 3, I go, that makes no sense because it says it requires 2/3 to remove the disability. So why are we now saying that if both chambers pass a bill to disqualify Trump affirmatively, that's the only way it could happen, when the language seems to talk about removal of disability? That's why I disagree with this opinion, but I'm just reading you the words of what the opinion is and why ultimately this is what the law of the land is, even though I disagree with. So now Justice Amy Coney Barrett, who was appointed by Donald Trump, what she's saying is, look, I join with the court's opinion. I agree that states lack the power to enforce Section 3. That principle for Justice Coney Barrett is sufficient to resolve the case, and I would decide no more than that. This suit was brought by Colorado voters under state law and state court. It does not require us to address the complicated question whether federal legislation is the exclusive vehicle through which Section 3 can be enforced. So you may actually find yourself agreeing with, of all people, Justice Amy Coney Barrett, but she's letting us know as well what it is that the law of the land is. And what she's saying is the following. Why did you, majority, go a step further and say that it requires federal legislation as the exclusive means to disqualify Trump? She's saying, I don't read it that way. By the way, I don't read it that way. But she's acknowledging that that's what the majority opinion is, that that's what the law is. So if you didn't believe my analysis, that's Justice Amy Coney Barrett's perspective of why she thought the majority went too far. And who's the majority? It's Roberts, it's Alito, it's Gorsuch, it's Clarence Thomas, and you have and it's Kavanaugh. It's those five right there. Now this is from Sotomayor, Kagan, and Jackson. While they believe that Trump is not disqualified as well, remember it's 9-0, they get there by a different methodology, and they're making it clear, somewhat similar to Amy Coney Barrett. Let's just go through it line by line. Allowing Colorado to disqualify Trump, we agree, would create a chaotic framework, a chaotic patchwork. But then these three justices appointed by Kagan and Sotomayor were appointed by Obama, Ketanji Brown Jackson by Biden. They go, yet the majority goes further. Even though all 9 members of the court agree that this independent and sufficient rationale resolves the case, the 5 justices go on. They decide novel constitutional questions to insulate this court and petitioner from future controversy. Can I read that again to you? They decide, the majority decides novel constitutional questions to insulate this court and petitioner from future controversy. Insulate from what's the future controversy? Right now, the majority insulated Trump from all of the situations right now. And they did that once again by saying it has to be federal legislation if you want to disqualify. Although only an individual state's action is at issue here, the majority opines on which federal actors can enforce Section 3 and how they must do so. The majority announces that a disqualification for insurrection can occur only when Congress enacts a particular kind of legislation pursuant to Section 5 of the 14th Amendment. In doing so, the majority shuts the door on other potential means of federal enforcement. We cannot join an opinion that decides momentous and difficult issues unnecessarily, and we therefore concur only in the judgment, meaning we concur with the outcome that Trump should be not disqualified. However, we disagree with how they got there. And to be very clear, they're saying the majority, and this is what I'm saying because this is what the majority ruled, shuts the door. What does shuts the door mean? Shutting the door means there's so much that I would love to do here, and I'm sure that you would love to do here, but it's saying the majority has shut the door to any other approach other than this federal legislation. And that's why Ketanji Brown Jackson and Sotomayor and Kagan write separately, because of what the majority opinion did in shutting the door to any of these other arguments that you may be hearing out there. Look, that was a long analysis, but that's what the Supreme Court ruled. It has to be federal legislation. Now, again, you can go back and read the 14th Amendment, Section 3. You can say, Ben, it's self-executing. He's an insurrectionist. He can't take the oath because I agree. But the Supreme Court disagreed and said Congress has to pass legislation for that to be the case. Section 5 says that. You may go, but what's the point about them saying that 2/3 is required to remove the disability? I think that it was pretty clear, too, that the disability is the insurrection. That's what Judge Ludwig said, that the disability is the insurrection and that 2/3 of, is required to remove that. That's not what the Supreme Court ultimately held. And I went through it methodically with you right there, why it is the case. And ultimately, the Supreme Court interprets the Constitution. They're the final say on this. So that's the full analysis. I'm sure the full analysis leaves you upset. It leaves me upset. But I wanted to go through every single page with you so you can finally see once and for all that the only path is Congress passing a bill, making it a law. And if they're controlled by MAGA in the House and Senate, it's not going to happen. We can petition, we can tell them, do it, MAGA Mike, do it. They barely could get a funding bill done. I mean, the continuing resolution, what do you think they're going to do? Introduce the bill to disqualify Trump? MAGA Mike's not going to even introduce the bill. And then when the Republicans take over the Senate, anyway, I think you've seen for yourself, we went over every page. You can go and read the full opinion. That's how I would teach this in my law class. And that's the status. In a perfect world, Trump would be disqualified. I agree with Judge Ludwig's interpretation. Anybody who thinks that the 14th Amendment, Section 3 should disqualify Trump, I've said it before. Let me say it again. I agree with that. The Supreme Court 9-0 disagreed, and the majority, which is the law of the land, says legislation is required. And and then there were the other judges that said, why'd you go that far? Why'd you go that far? That's the status. The Supreme Court rules. There's no one who can overturn the Supreme Court. There's no one who sits above the Supreme Court. That's it. Professor Meiselas' class is closed. Thank you.
Real quick, Meta just changed their algorithm to suppress political content. Please follow our Instagram @MeidasTouch right now as we head towards 400,000 followers so you don't miss a beat.